May it please the court, Lawrence L. Free on behalf of Johnson County Sheriff Frank Denning. I would like 12 minutes for my argument, and Counsel Delaney will use 3 of my 15 minutes.
That's granted.
After 6 years and 7 hearings before various decision-making tribunals, the core issue in this case remains who decides who works for the sheriff. The elected sheriff, or 3 volunteers appointed to a civil service board.
Is that really our determination here? Is that really the issue on the table for us? Is whether the first CSB board simply couldn't perform its function?
I think the issue is what deference did the first civil service board need to give to the sheriff as an elected official. And they didn't give any deference to his decision, which, by the way, was entered into after considerable investigation and due process and a full-day hearing afforded to Mr. Maurer. Did the sheriff make the decision to terminate him?
So from a legal argument, you're saying that they exceeded their authority?
I think, yes, they exceeded their authority, just as Judge Vano found in his decision and as the majority found in the appellate court decision. They exceeded their authority because the sheriff is the elected official. He's elected by the population, the taxpayers of Johnson County, and he's the one who's entrusted with upholding the law in Johnson County.
But you would agree it's not unfettered discretion?
I would
Because
agree.
the creation of the CSB was to supervise the exercise of that discretion or to protect the rights of the workers.
At least provide some check and balance to an unfettered, evil sheriff's authority, which we don't have in this case. But keep in mind, too, that this civil service statute that we're talking about is over 40 years old. It was enacted in 1969, I believe, long before there were all the HR bodies of law that came out of the federal government, out of the state governments regarding discrimination on any possible basis, and so on. It's an old law. And what's happened in the sheriff's office in Johnson County, there are 550 sworn deputies and another 100 or so civilian employees. It's a big operation, and the sheriff has taken over the HR functions of what was originally intended to be performed by a volunteer civil service board. There's no way a civil service board can do what the sheriff's HR department does now.
What are the
Go ahead, Mr. Thompson.
What are the boundaries of the board's authority to review what Sheriff Denning did?
The boundaries are set out in 1943-27, A, B, C, and D. And A, subsection A, says that the sheriff can dismiss employees for the good of the service. However, he cannot do it for political, religious, or racial reasons. And there have been no allegations in this case whatsoever that there have been any improper reasons behind the sheriff's motivation to dismiss Deputy Maurer. The other subsections of the statute say that the Civil Service Board has the right to review the reasonableness of the sheriff's actions, and they can reinstate, they can uphold the dismissal, and so on. But what the problem we run into in this case, which is exactly what the Nylander court dealt with in Nylander, this court did, is reconciling the sheriff's statutes that describe his office and his powers, 19805. 19805A says the sheriff has the right to hire, promote, demote, and dismiss his deputies and other assistants. And that's what the Nylander court reconciled when it said, look, there are other statutes that give a board of county commissioners authority to pass personnel rules and regulations, and that the subject to that is referenced in 19805, I believe it's D, it's either B or C, or B, I'm sorry, B or D, says that the subject to doesn't mean that the sheriff is subordinate to the Board of County Commissioners, but it means that the county can pass these personnel regulations in a general sense, but when it comes to individual disciplinary actions against an individual employee, it is the sheriff's jurisdiction and his authority to take that action. And I don't see how the fact that there's a civil service board in the mix changes any of the analysis that the Nylander court went through. Certainly, if the Board of County Commissioners can't tell the sheriff who to hire and fire, their appointees can't either.
Well, in reviewing the reasonableness, if that's their task, the Civil Service Board's task, how do they go about doing that without doing what they did in this case?
I think they employ, and they should have employed in this case, just as Judge Vano held and the majority in the appellate court held, that you need to see if there's sufficient evidence to support the sheriff's decision. And if there is, then you have to uphold it. You can't substitute your judgment for that of the sheriff. If there's evidence to support what he did, and in this case, there's an abundance of evidence to support what he did. It took 4 tries to get Mauer's supervisors to hear the whole truth. 4 tries. This is a law enforcement agency. Come on. What law enforcement officers say and what they don't say can deprive people of their freedom. Truthfulness is a very important policy.
Counsel, I'm having trouble with your argument because this is a creature of statute, this board, and the statute provides what the board's supposed to look at. And so I have trouble looking outside of the statutory language and trying to impose some other restriction on the board that I don't read in the statute. The statute says they're supposed to determine the reasonableness of the action. That's all it says. And it really seems like you're trying to import restrictions on the board that aren't provided in the statute.
I disagree respectfully that the Nylander court wrestled with this same issue. And that is, you need to read all of these statutes in harmony with one another to make them make sense.
The Nylander court, you probably ought to address that before you follow up, because that, according to Mauer, and I think that's true, and your position's been rejected at least by the Court of Appeals, because Nylander involved the Board of County Commissioners. It didn't have anything to do with this Civil Service Board.
No.
Or its review. And assuming that we don't accept your argument about Nylander, I guess I'm hoping you'll address the question that Justice Biles raises about reasonableness, not talking about Nylander, but just generally, what does reasonableness mean? What kind of review is that?
Well, I think we have to start with what authority does the sheriff have in his position? I mean, does he have the authority to hire, fire, promote, demote, dismiss his employees? The statute says he does have that authority. Is it reasonable for the sheriff to say, I don't want a dishonest employee working for my department? And what is the evidence that supports that?
What's your position other than Nylander to support that a reasonableness standard, which is all we've got under the statute, does not permit them to do their own fact-finding, essentially a de novo review?
Well, I think that they have to look at the evidence, and they have to look at all the evidence. And what happened here was
What do you rely on for that? What other than Nylander, what are you relying on for what they do to determine reasonableness, what the Civil Service Board can do in determining reasonableness?
I would first say intellectual honesty. I mean, let's look at all the facts. What happened here is they took some clever cross-examination, and they took written reports where clearly not the whole truth was told about how the windshield got broken. And they said, we find those reports to be truthful, even though they're clearly half-truths. And they didn't look at the rest of the evidence. And now they're asking the appellate courts all the way up the chain here to look at half-truths and call them truthful and say, therefore, the deputy was truthful because of his half-truths. They didn't look at the other half of the evidence and the facts that were untruthful, that he left out. And going back to the sheriff's policy of truthfulness, it clearly says that you can't omit to tell the truth. That's what's going on here, is they're not looking, or they're asking the courts to look at half the evidence. And that's not intellectually honest.
If we were to take your argument and put it in appellate terminology, are you basically saying that the term reasonableness is that the board would look to see if the sheriff's decision, or if the sheriff abused his discretion in making his decision? Is that kind of the standard of review that they would have?
I would say whether there's competent evidence to support his decision.
Which can be part of an abuse of discretion standard. I mean, a lack of factual findings to support the decision is an abuse of discretion.
Yes, I would agree with that, and I think Judge Vano addressed those issues in his opinion and said that they were arbitrary and capricious. They didn't adopt any rules, and we had been arguing with them for 2 years before the Maurer hearing that you need to define your standard of review, you need to define what your role in all of this is. The county attorney got involved in it, came up with recommended revisions to the home rule charter, and the chairman of the Civil Service Board knew about all this and didn't follow it, and wouldn't tell us ahead of time what their standard of review was and what kind of hearing we were going into.
So if we were to ask you for your dictionary definition of reasonableness as it fits into this situation, what would your definition be?
I would say let's look at all the evidence and decide whether it's reasonable to conclude that there was no evidence before the sheriff when he decided to terminate Maurer. And it's clear that that is not an accurate or honest evaluation of the entire evidence before the Civil Service Board.
And when you say look at the evidence, do you mean have an evidentiary hearing type hearing, or just review on the record the evidence that's been developed by the sheriff?
Well, I think that it should be on the record if the record, just like the new civil service ordinance that was passed by Johnson County says, if the sheriff has made a complete record in his internal disciplinary procedure, then the review of the Civil Service Board should be on that record that was made. If it wasn't based upon a complete record in the sheriff's internal process, then they do have the right to conduct an evidentiary hearing.
The board's opinion says that CSB specifically finds and concludes that the two reports were by all accounts truthful. It says, see testimony of Sergeant Greenwood, beginning at page 68 of the transcript. In response to questions from counsel, Greenwood concedes that the reports were truthful. The only issue was that Maurer, was not as specific as he or Lieutenant Pinkelman wanted him to be. So they are citing to a transcript several pages here, and apparently that is what Sergeant Greenwood testified to. So are you saying that that evidence is not on the record, or that they made the wrong finding based on that testimony, or that's just part of the equation? They should be looking at other evidence.
I think they should look at all the evidence, and it's clear that Greenwood went on to testify that he omitted facts. And the facts that he omitted are that he tossed this 5-pound blue folder on the dashboard of his patrol car to kill a horsefly, and he broke the windshield. He left that out of the first Post-it note. He left it out of his verbal report to Sergeant Greenwood the morning of July the 27th, the next morning after the windshield was cracked. He left it out of his first written report. after Sergeant Greenwood asked him to prepare a report and be as detailed as you can. He doesn't say that I threw the blue folder on the dash to kill the horsefly. He leaves it all out. Finally, even his partner, Deputy Eddie, had to come in and tell Sergeant Greenwood what really happened. He didn't get it from Maurer, he got it from Deputy Eddie. Then finally, the fourth report mentions the throwing the blue folder on the dashboard. Did the first Civil Service Board look at all that? No.
Well, here's what they said they did. They said that the statute 1943-27 is not limited to just the evidence that was considered by the sheriff at the time of the dismissal, but also includes the entire record of the evidence presented at the CSB hearing. They go on to say, CSB reviewed every document introduced, considered the testimony of all the witnesses, and the legal arguments advanced by both the parties in person and in writing. After a thorough review and consideration of the evidence, then they conclude that Mr. Maurer should not have been dismissed. So are you telling me that they are untruthful here? That they did not, in fact, review all the evidence as you want them to do? I'm having trouble understanding what your position is.
I'm saying they could not have reviewed all the evidence. They couldn't have looked at the record or the transcript of the Professional Standards Board hearing that was made on a 6-hour hearing before 5 of Maurer's peers, who, based on the evidence that they heard, unanimously determined he violated the policy and unanimously determined they did not want him as their partner. And if they didn't, then they didn't think they should ask anybody else in the department to be his partner. That was the basis on which Sheriff Denning decided to terminate Deputy Maurer. Now, did the first Civil Service Board consider all that? No. They found there was no evidence whatsoever to support the violation of the policy. How can that be? It just is not factually supportable. It's not intellectually honest to say that there's no evidence, when clearly there is.
So the board is being untruthful in their report when they said, yes, they reviewed all the evidence and came to this conclusion?
I think they have to be at least in error, because I don't see how any reasonable person could review the transcript that was made at the Professional Standards Board hearing and say there was no evidence. They're basically saying that a captain, 2 sergeants, 2 master deputies, they're saying Sergeant Greenwood, Lieutenant Pinkelman, Captain Rector, who did the PSU investigation, and they're saying the sheriff had no basis to do what they decided to do. That is unreasonable. That is not believable. It's just not acceptable.
All right, thank you, counsel. I see you're out of time. Do we have any further questions of counsel? Thank you.
May it please the court, Your Honor, it's Michael Delaney for the Johnson County Sheriff's Civil Service Board. Counsel for the sheriff was kind enough to give me a few minutes. Given the nature of the court's questions, there may not be much for me to do, because the Civil Service Board, the newly constituted Civil Service Board, didn't take a position with respect to the validity of the first Civil Service Board's decision-making. We weighed in on the case only to protect the integrity and the validity of the second Civil Service Board's decision, and to appear in case the board was inclined to rise to the bait isn't a fair characterization, but the comment in Judge Levin's dissent suggesting that perhaps the county didn't have the authority to modify the standard of review that the new Civil Service Board exercises. And I'm prepared to argue that issue. He mentioned that it hadn't been referred to in anybody's briefs. But if there's a concern on the part of the court that there was some deficiency in the second Civil Service Board's proceedings by virtue of the fact that that the standard has been tweaked in a way that doesn't give a sort of carte blanche, but actually defines the new standard as the Civil Service Board looks to see whether the sheriff's decision was clearly unreasonable, and sets that sort of as the boundaries of what this determination is, much as an instruction that employers seek all the time in discrimination cases, an instruction to the Civil Service Board, look, it's not your position to substitute your judgment for the sheriff. If a reasonable sheriff could come to that decision, then you're stuck with that, even if you wouldn't come to the same position in your business. And the county and the new Civil Service Board believe that the new regime that's in place now represents an appropriate balance between the sheriff's prerogatives that are set out in statute and the requirement that there be some oversight, some avenue for redress if a decision is manifestly unreasonable or arbitrary or capricious or unfair in some market way. Beyond that, I think as counsel has indicated, if the merits of the second Civil Service Board decision come under scrutiny, the decision is clearly within the authority of the Civil Service Board. It's clearly supported by ample evidence in the record that the decision was supported by the evidence.
But they decided to.
And it was manifestly not fraudulent, arbitrary, or capricious. So it's entitled to.
Counselor, but the two boards decided two different questions.
Well, I don't think so, Your Honor, necessarily. I mean, I think the issue is, did the first board feel in any way constrained by an obligation to provide some deference to the employer's responsibility for hiring and firing, which is set out in a part of the statute that can't be modified.
Did I understand you to say that the second board looked at whether the sheriff's actions were clearly unreasonable?
That's correct.
And the first board looked at whether the sheriff's actions were reasonable?
That's correct, Your Honor.
And you don't see that as being two different decisions?
Well, I mean, I think, sure, it's like a jury given an instruction, you determine reasonableness, and being given a limiting instruction that you shouldn't take these factors into account, or you must take those factors into account. I think ultimately the decision, the standard is the decision reasonable, but it's not, is it reasonable according to the way you, Civil Service Boards, would govern your business? It's, can a reasonable sheriff have made that decision? But in any event, my time's up.
Do we have any further questions of counsel? Thank you, counsel.
Thank you very much, Your Honor.
You reserve 5 minutes for rebuttal.
Thank you, Your Honor. May it please the court. Returning to our discussion about the exchange during the hearing, where the issue was isolated that was going to be resolved by the CSB. On page 27 of the CSB's transcript, and this is after the parties and the board had begun focusing on the report and the amended report, and any gap in the first being filled in by the second. Board member, is that all this is about? Mr. Maurer, and this is actually Mr. Maurer testifying, that's all this is about. Board member, is that what you're saying, Larry? Mr. Free, that's all this is about, the difference between these two reports? Counsel for Maurer, yes. Mr. Anderson, which is the board member, is that right? Mr. Free, counsel for sheriff, that's what the record reflects? Yes. That's on page 27 of the transcript. And that's where the parties are focusing on just the differences between initial report and amended report. And I think that is just one of the ways the Civil Service Board, and in their decision, you see referenced two reports. Now, the Court of Appeals has 4 bullet points, and they reference more statements than that. But the CSB clearly honed in on the report and then the amended report. And right there in the record is the reason for why they did that. A board member specifically isolated that issue and framed it, and the sheriff agreed that, yes, we're here because of the so-called differences between first report and amended report. And again, Sergeant Greenwood came in and testified that in his experience, he himself has amended reports in this way, and it's never caused any repercussions before. He's been told to fill in gaps in detail, and he's done so. The first CSB did not exceed their authority. The statute says they're entitled to review reasonableness. That's obviously a totality of the circumstances type analysis, and that's exactly what they did. They looked at Mauer's career, overall career. They looked at the incident. They said they reviewed all the evidence, which is exactly what they did. Moreover, on the idea that there has to be deference granted to the sheriff based upon the preliminary evidence developed, it's undisputed that the CSB was entitled to collect new evidence and hear new evidence in the first instance. How can it be simply a review if they're hearing new evidence that wasn't part of that pre-existing record? It can't be. They're hearing evidence for the first time. That's not a review type proceeding. That's de novo proceedings. They're hearing evidence for the first time. They're doing more than just reviewing a record. Sure, some things were admitted as exhibits, but they heard live testimony that was never given to the sheriff. They judged the credibility. That cannot just be a review. They heard live evidence that was not in any pre-existing record.
Do I recall correctly that the CSB board has subpoena power?
They do. They do. And they're quasi-judicial, and they, as Judge Lieben noted, they're the ones entitled to make the discretionary quasi-judicial-like determinations in the case, and that's exactly what they did. Nylander doesn't have anything to do with the Civil Service Board. That was a board of county commissioners that I think the court's already recognized during the proceedings today. And the statute doesn't say that the sheriff's decision is subject to the county commission. It says it's subject to their Civil Service Board, and that's what we had here. In fact, the subsequent Zellner case, although it might not hold squarely, it provides good language clarifying that the subject to language does extend to Civil Service Board hearings. Now, in that case, they didn't like the exact remedy given by the Civil Service Board, but it was undisputed they could have just simply reinstated the employee. They had that type of authority, and that's the authority that was exercised in this case. The idea of half-truths, that can probably be debated. But that was the Civil Service Board's call to make, as Judge Lieben said. Somebody has to decide whether or not an omission is significant enough to constitute intentional dishonesty. That's by its very nature a discretionary call. Two reports are going to always contain varying information, and not in all situations is there going to be dishonesty. Somebody has to determine, okay, was that material? And okay, if it was it intentionally?
Wouldn't it be better to have the folks who work with him and who supervise him and who employ him make that determination about whether they believe that to be a falsehood or incomplete information than someone?
Not in the system we have. The system we have by the legislature specifically brings it outside the department because there can be other problems created by it being done in the department.
Well, it depends on what you think their reasonableness standard is.
That would play a role in it.
Kind of depends on that, doesn't it?
That would play a role in it. But I do think that we're just governed by the statute, and the statute does take it outside the department. And I think that's the end of the analysis.
Would you like 30 seconds to wrap up, counsel?
I would just like to conclude if I could. I would just state again that Mr. Mauer respectfully requests the court to enforce the first Civil Service Board's decision and see that he's reinstated pursuant to it. Thank you.
Any further
Can you
questions?
also give me your definition of reasonableness then?
Well, I think that as I think I briefly referenced, I think reasonableness is a totality of the circumstances type test. It's not was a single policy violated or did this exact act occur. It's viewing everything, and I agree everything has to be viewed. When I say somebody's not viewing the entire record, I'm talking about the court subsequently. I think the CSB did and should have reviewed the entirety of the evidence. And I don't know if reasonableness is a type of word that's subject to a mechanical definition. I really don't. I think the CSB looked at the facts, looked at the evidence, and as Judge Lieben said, basically said, based upon what we're seeing here, it's unreasonable to fire this deputy on these facts. And that was their determination to make. There is some discretion built in there. But as Judge Lieben said, the statute vests them with that discretion, and they exercised it. Are there any other questions?
In just reviewing the CSB's order, I don't see where the word reasonable appears in it.
It does not those precise words. If you read it from top to bottom, as Judge Lieben says, it's clear that although the words don't appear there, that was the basis of their determination, that it was unreasonable to terminate the deputy under these circumstances. And, you know, the order of reinstatement alone shows you that they thought it was unreasonable. I mean, that's the type of conclusion you make when you think a termination is unreasonable. You state in your written order, we hereby order him reinstated. And then you've got all the facts they laid out, which, and I've already gone through them, I'm not going to go through them again, or at least I've referenced them, that show their belief that on these facts, this termination was unreasonable. I think it's too rigid to require a local administrative agency to use magical wording in order for its order to be enforced. I think that the spirit of the order has to be reviewed, and it's clear that the spirit of this order shows they thought that this was just simply unreasonable.
And that was based on facts as they found them, that there was no violation, because that was the number one fact they found. They found it.
Well, that was one of their findings.
That was the number one finding. It was pretty significant. There were no violations, and the violations were what the termination was based on.
And I think that where they get there, Your Honor, is that discretion about, okay, is every omission a violation of the...
I understand. I'm saying, but you can't divorce the finding that there was no violation from the reasonableness determination. You can't divorce those two things.
Well, I don't... Perhaps the order could have been drafted a little more, you know, with a little more precision. I think, again, yeah, you have to view that. That's in their decision, and I don't think we have any problem with that being part of the analysis.
Well, how could you? Because that was the basis for the termination decision in the first place. Not all these other things that they talked about.
Right. Well, I think I've said.
Thank you.
I think I've already
you
answered
my question.
as best
Thank
I can, Your Honor.
you.
Thank you.
Thank you.
Any further questions of counsel? Thank you, counsel. Thank you all for your arguments this morning. Clerk will take this matter